Saturday morning, afternoon, evening, depending upon where you are in the city. Thank you for joining us on From the Halls of Justice. We have with us today our special guest, and when I say with us, I mean my colleague and co-producer, Murvet Arnstein, who's in the studio with us. We have with us our very special guest, Mr. Russell F. Behjatnia, Esquire. He is a wonderful attorney, and he does family law, but today he also does personal injury. He's a partner at his firm, and he is going to educate us on personal injury. This is a first for us from the Halls of Justice. We've never done a personal injury show. We're normally family law girls or something, or doing international law with Amanda Knox trial and Bill and Steve. So this is terrific. I'm going to throw this over to my partner and colleague, Murvet Arnstein. Will you take us into this, please?
Can you give us an overview on personal injury in California?
Of course. Good day to everyone. Personal injury is an area of the law that's covered under the category called torts. Anything that causes an injury or damage to someone else, and it's not a crime, it is considered a tort. So if anybody would cause a damage or injury during robbing a store, that is a crime, and that would be subject to criminal prosecution. But if somebody causes damage or injury to somebody else during what we call a non-criminal events, such as driving a car, such as building something, and then as a result of that somebody would be injured, that would be a tort. And in the state of California, that covers the factors that would go into determining if in fact a tort took place, and if there should be some kind of a compensation for the person who suffered the injury or the damage.
I see. Okay, then what is our duty to others? Well,
duty is what determines that one person is liable to another or not. In California and in United States everywhere, the concept of duty and our responsibility to others is similar and identical. We have a duty to conduct ourselves in a reasonable fashion, to use what is normally very easily understandable by everyone is driving. If we are driving on the road, we have a responsibility to drive responsibly and carefully, considering the right of others on the road. If we happen to lose control or to do something that is going to be causing an accident, then that duty has been breached. And we are going to be responsible for the resulting damage to property, to cars, to homes, to phones or other belongings that we have. We're also going to be responsible for the injury that we cause to individuals if they are hurt.
So being negligent is the same as not being careful?
Exactly. It's the word negligence is used in this area a lot, and we are going to be using that often when it comes to the area of tort and personal injury. And we say that an individual was negligent in the manner in which they built their home. Therefore, because of that negligence, when I was walking in a certain area, the floor underneath my foot gave way, it broke, and I fell. The person who owns the home and the person who built the floor in a manner that was not sturdy or proper enough, that eventually broke and caused the injury, are negligent. So therefore, they have basically not done the proper duty when it comes to building, which is the same example that we gave earlier about somebody driving their car and striking another person or another person's car and causing damage to their vehicle.
I see. So what standard is used?
The standard that we use is the standard of a reasonable, prudent person. if you are going to be driving a vehicle and you're going to be conducting your driving in a manner that's going to be a reasonable person would be driving under those circumstances, then you have not breached your duty. You have done the proper conduct. However, there are times that, using again the example of a structure, that we can look at the way a building is built or the manner in which something is put together. And we want to know if this table right here is built properly, or this is basically not meeting the minimum standard of table making. For that, we compare the work of the carpenter with the work of a reasonable and prudent carpenter. We're not going to compare that work with the work of the best master in carpentry that comes from Italy. That would be too much of a burden. Nobody can reach that level, or hardly anybody can reach that level. The law places the level of comparison upon individuals of a reasonable, prudent person. What would another person, a regular, ordinary person under those circumstances do is the standard.
I see. So how do we know who is at fault then? You know, how in accident?
Then what we do is that we are going to go to those standards. Using driving, for example, there are standards already in place, and all of us who are driving follow them. The standard says when you see a stop sign at any intersection, you need to stop for it. That is the standard that we need to follow. The law says that if you went through that stop sign without a proper stop, and as a result of that you cause an accident, and you would be at fault. So those standards for driving is what the law says, and what the vehicle in the United States, in all basically states, are very much similar states. And in California we also have a set of codes that cover that. What is going to be the standard in other areas is also relative to what area of event, practice, or conduct are we talking about. The standard, for example, for a police officer is going to be very different than the standard that we have for a regular person when it comes to conduct that a police officer should know better to do or not, such as placing a person under arrest. If a police officer is going to be conducting an arrest, the standard is that he needs to follow the proper procedure that that police department determines to be the correct one. If he does not follow the proper procedure, then what he has done, he has basically gone beyond what is allowed, so therefore there might be some liability or responsibility to the individual who, as a result of that improper conduct, was injured.
So could more than one person be responsible?
Absolutely. We gave earlier an example in which we talked about a person walking through a house, the floor giving way, and that person falling. Depending on certain other factors, there could be liability on more than one person. For example, one of them could be the liability on the owner of the house. The law would require that the owner would be having a household or a structure that is up to the standards, up to the minimum standards of building and safety codes. There could also be liability on the person who was involved in building that home or building that floor. So there could be more than one person responsible. In other more common examples, in car accidents, when you are driving a vehicle, if you do something that is not correct in the process of driving, and as a result of that you cause injury or damage to somebody else, it's clear and all of us can understand that the driver would in fact be responsible. However, if the car that we are driving is owned by somebody else, that owner of the vehicle who allowed you to drive their car would also have some liability, and therefore in the state of California, we have a requirement that every vehicle on the road has to have insurance, whether it's your vehicle or not. So people cannot stay away from liability by saying that, yes, my vehicle was not insured, I'm not responsible because I wasn't driving it. The person who was driving it is responsible, and the state makes it a mandate that if your vehicle is being driven on the road by you or anybody else, you have a certain amount of responsibility to the other people on the road. However, there is a limit to that, and then the majority of the responsibility would be on the driver who actually did the wrong thing.
So how do we measure damages?
Measuring damages would be as simple as sometimes getting an estimate. Let's say that in the process of painting a house, a worker dropped a bucket, and that went through a window and caused damage to the window. We have a broken glass. It was not done purposefully, so therefore it's not a crime, as we talked earlier, so it would be a tort, which means it's an injury. The owner of the house suffered a broken window. What is the measure of that damage? Is the estimate that we would get from anybody who is going to be able to fix that window for us and put a new plate of glass in there.
Right.
The same example can be used if we are going to be looking at car accidents, is that as a result of two cars colliding, if there's going to be a damage to one or both of the vehicles, those vehicles would be evaluated by people who are assigned by the insurance companies to evaluate them, called adjusters. The adjusters will take a look at the car and come up with an estimate. That estimate would be for the repair of the vehicle. That repair would be to try to put the vehicle back together, paint it, and repair it in a way that it would be as close as possible to its condition just before the accident. So that estimate that you would get from the body shop or from another location that the repairs would be done at would be the determination of amount of damages. For an individual, if they're injured, the amount of damages would be based on how much in medical bills they needed to incur in order to feel better or to go back to their condition just before the accident. And also, in addition to that, what would be their pain and suffering? Of course, as a result of the accident, if they're injured, not only they had to pay their doctors and hospital bills, but they also had to endure a certain level of pain and discomfort that by law it would be compensated.
Wow, that's great information.
Yeah.
And what I really enjoy is now I know what a tort is. When I was in school for paralegal school, we had to study these, and you know, we were kind of joking saying a tort is like a dessert. But so now I understand a tort is an injury not having to deal with a crime. So that's good. Also, I guess with the home problem, if you were going to sue somebody, you're going to sue the homeowner with the damaged floor, and the homeowner would probably go after the contractor who didn't do the floor correctly.
That is correct.
Yeah, we got this. I like this. Now, with personal injury, what are some examples of personal injury?
Personal injury, and the reason why we use the word personal in there, because most of the time it involves a person.
Okay.
It involves an individual who suffered an injury. It could be a car accident. It could be the defective floor we were talking about that caused somebody to have a hurt foot or a knee injury. It could also be as a result of a medical conduct. What if we go to the hospital and the program is that because of a certain condition, one of the patient's kidneys have to be removed. And all of the exams show that the right kidney has to be removed. When the patient is taken to the operating room, mistakenly the left or the healthy kidney is removed. So it's clear without even needing an expert to look at it,
Right.
that this person has a personal injury in form of medical malpractice. What happened here, this person not only did not get the bad kidney removed,
Right.
he lost his good kidney. So that's an extreme example of why we call this personal injury, is because it involves injury to a person.
So this is overlapping the next question, which is medical malpractice a type of personal injury?
Absolutely,
So,
it
yeah,
is.
okay.
And using the example that I gave earlier would be, of course, an extreme example of situations like that that unfortunately do take place.
Yes,
However,
they do.
thank goodness they are rare. Medical malpractice, as the words explain, has to do with the conduct of a medical professional. Let's say a doctor, a surgeon, it could be a pharmacist, it could be a dentist, it could be a nurse, anybody who is a medical professional. If during the course of their activities and providing care to a patient, they, let's say, administered the wrong medication or the wrong procedure, and as a result of that, that person suffered an injury, well, that would be also subject to compensation based on exactly the same rules that we were talking about, which is comparing the conduct of the medical professional to the conduct of another medical professional in that same specialty, and then be able to determine if they breached their duty to their patient.
Wow. So when do we need experts, and do you have any, well, this is going to encompass a couple of things. I was going to say, do you have any comments on the Murray, Michael Jackson's trial that went on?
The
Okay.
Dr. Murray
Yeah.
case,
Okay.
Well, the use of experts could be as simple as using, let's say, somebody who is specialized in the area of repairing the vehicles. That would be an expert too, is a person who would tell us, for example, what caused the damage to this vehicle and what would it take to repair at a different venue. However, use of experts usually comes to play when we are talking about the standard of care in a medical malpractice case. If, as a result of something that a doctor did, a patient was injured, just because the patient is injured, it doesn't mean that the doctor has done something wrong. Because we have to remember that every procedure, every surgery has with it and carries with it a certain amount of risk.
Yeah.
Exactly, that they have to accept.
Right.
We all as patients have to accept. Not every procedure has to go perfect. Now, who would determine if this particular damage or injury to an individual was subject to compensation is an expert. So an expert would be hired who is educated and has experience in the same area. They look at the records and they would determine that, is it true that if this doctor or this medical professional had conducted themselves based on the minimum standard of care, this wouldn't have happened? If the answer to that is yes, and if they had breached that duty, then there would be a liability to the person who suffered the injury. So expert would be the one who would be telling us if there was a breach of the minimum standard of care.
Well, evidently they thought there was. So, when do we go to court? I mean, hopefully the person doesn't die or it's not to their demise, but so when do we go to court?
We have a period of time that is set by law in the state of California, during which we try to resolve our differences with the person who caused the damage or injury.
Okay.
That period in the state of California for a personal injury case, which is different than a medical malpractice case, in a typical personal injury case is a period of 2 years.
So it's different in personal injury than medical malpractice?
That is correct. Because
So, okay, what would be the time frame for medical malpractice?
that would be 1 year.
Really?
It is less, yes.
Okay. Why?
Because the law wants a professional, such as a doctor, to not have to worry about a lingering potential suit or claim
Okay.
to be going on for too long.
Okay.
Let me give you a better example. if somebody has a personal injury on a city bus, which is a governmental entity, and the driver of the bus was negligent, so therefore the cause of action would be against a governmental entity such as the city, the county, or the state of California, then the statute of limitation for that is even less. It's only 6 months.
Wow.
So the concept behind that is that they don't want the government to be sitting back and waiting at a lawsuit some 2 years later. They would rather, at some point, the legislature decided that it would be best if they know about it as early as possible. So therefore, they put lower limits of the length of time that you have to go ahead and seek some kind of a recovery. And in various parts of a personal injury, it's different. But as a whole, in, let's say, a car accident or an accident that happens at a property to a person, that is 2 years. But the subcategories are different, including up to the limited amount of time, which is 6 months, even though it was caused by a car accident. But if you had the car accident, for example, with a, let's say, CHP vehicle, which is a state of California owned vehicle, then
6
your time
months?
is immediately down to 6 months. Exactly.
Wow, you're good. This is a lot of stuff to remember. I think it's, wow, that's interesting. So how are insurance companies involved?
We talked earlier that about the requirement in the state of California that every driver and every vehicle on the road to have proper insurance.
Yeah. Okay.
The reason we buy insurance is because we are saying that in case something happens and something goes wrong and there is an accident, we want to have a source from which we are going to be compensated.
Okay.
The insurance companies get involved for the compensation of the injured person or the damaged goods.
Okay.
If that person's injuries are going to be compensated and being paid for, an individual who does not have insurance would have to pay them out of their pocket. The insurance would be coming to play. By having it, the insurance will take over and will compensate the person who is seeking damages.
So this covers what you just stated about the insurance company covers the person that are seeking damages. When the question would be, when we file a lawsuit, are we suing the insurance companies instead of like suing the person or something like that?
That is a very good question, because that's a misconception that a lot of individuals have, that great, I haven't been able to really be compensated by the insurance company, and they haven't made me a good enough offer, therefore I'm going to sue the insurance company. You do not sue the insurance company. What you do is that you file a lawsuit against the person who caused the damage or the injury, which is the other party. Let's say the party at fault.
Right.
Let's say the other driver in an accident.
Okay.
The insurance company for the other driver will have the responsibility to defend them. And if that person is found liable, the insurance company will have to pay the money. But you do not actually have a lawsuit in which you are the plaintiff and the insurance company is the defendant. It's not in these circumstances.
Who pays for damages?
The damages are paid by the responsible party, by the negligent party.
And the court determines that, or?
Exactly. If we have to go
the
to
insurance
court,
company. And what if you disagree with the insurance company on who caused the accident?
that's when you end up going to court.
Okay.
That's when you end up going to somebody who's going to be the judge of that. Somebody would be determining that based on the factors that are presented. The insurance company would have also a lot of experience in being able to determine what would be a reasonable recovery in a case. But if you do not come to a mutual agreement, then the final arbiter and the decision maker in that process, whether who's at fault and how much money is to be given from one to another, is the court.
Okay, because so that does sort of leave you a recourse, because I'm thinking, don't most people feel, let's say the insurance company comes back with their report on who they think caused the accident, and you disagree with it. You don't just have to accept that, correct?
That is correct, and that is what is very important for people to know, that they have a recourse. There is a possible avenue through which you would be able to have your day in court
Okay.
and your side of the story to be heard. If the insurance company is not being reasonable in the amount of money that they are offering for what we call the settlement of the case, then you can file a lawsuit and go to court, and in that process the judge will listen to you, will also of course listen to the other side, and based on that make a determination. Let's see who's at fault, and if there is a fault, let's see what is the consequence, let's say the financial consequence of that fault.
Okay. Well, that's good. I'm glad that we have a recourse, because a lot of people feel that once your insurance company rules on something like that, that this is it. You know, this is gospel, this is Bible, and we have to go with it. And I know of one particular case in particular that someone disagrees with them. And so the insurance companies are taking it to a board of arbitration or something. And so hopefully we get to hash it out that way.
That is correct.
Okay. Well, this is interesting. So you really have to have your guidelines set on the difference between medical malpractice, personal injury, if it's a tort, if it's personal with personal property, and if it's a government entity.
That is correct. That would make a determination. then you would be able to make a determination so you don't lose your rights. While you do have a right to go to court,
right,
you don't have a right to go to court whenever you want. There is a time limit during which you have to start your case in the court system.
Beautiful. Okay, well, we have 1 minute. We're going to wrap this up. Is there anything that you would like to tell our television audience that we should remember in particular? I know I have my notes, 6 months, 1 year, and 2 years.
In addition to that, I would recommend that if there is going to be an accident or any other event that causes damage or injury, to take good notes, have good information. Of course, during that time, we're not feeling well, we are scared or concerned or injured, but during that time it's very important to gather good information. Thereafter, it's going to be very difficult to be able to put the data together, therefore it makes our job of recovery more difficult for us.
Excellent. Well, thank you. Thank you very much. We're wrapping it up. This has been our first personal injury show. I thank you for joining us from the Halls of Justice. Murvet, thank you so much for being here. And Mr. Russell Behjatnia, very knowledgeable. Thank you so much for coming.
I thank you for your time.
See you next week on From the Halls of Justice. Tune in.